Page 900, para 23.
At 900.
Yes, at 900. As such, the governor has no discretion under Article 200. The issue of discretion does not arise under Article 200. The provision imposes on the governor a constitutional duty to act in many of the three courses of action: assent, return, or reserve based on the nature of the bill presented to him. These are not discretionary choices, but constitutionally mandated routes. Now, how they are to be operated, we'll deal with it. The issue of whether the governor is to send the bill back or reserve it for the consideration of the president on aid and advice of the council of ministers is immaterial, as the governor is not vested with the power to take any final decision on the bill, except assent to it. As seen above, the power to withhold is only recommendatory. If the governor believes amendments are required, he may return the bill for reconsideration, but once the legislature sends it back, he shall not withhold assent therefrom. But the argument is he can still withhold dissent, and further, that he can send it again to the president. It can't be done. There is no choice. But once the legislature sends it back, he shall not withhold assent. There is no choice. Likewise, if a bill derogates from the powers of the High Court, governor shall not assent, but must reserve it for the president's consideration. In neither situation is the governor exercising discretion. He is only following the mandate of 200. Regarding the first proviso, 200 as separate from the substantive part creates an absurdity regarding money bills. That's something that your lordships mentioned. That if he can withhold assent, he can also withhold assent on the money bill, because that's part of the proviso. But that will be an anomalous situation. So, therefore, I'll skip this, Mullah. Then Article 200 cannot be read in a manner to create constitutional impasses and litigation between constitutional functionaries. You can't interpret the Constitution in a manner that will create more litigation. But personally, I think that 361 has not been accurately or constitutionally interpreted in the context in which it should be read. Otherwise, Balas, you'll make 200 unworkable completely. The sequitur of giving governor the power to reject a bill will inevitably lead to litigation between the state legislature and the governor, as it has, embroiling the executive and the legislature in protracted conflict, thereby paralyzing governance and defeating the spirit of parliamentary democracy. Conjured facts have no relevance to the issue at hand, Mullahs. All these facts that my learned friend mentioned, if he deals with foreign affairs, if the legislature deals, these are all conjured facts. And your lordship should not even look at it. You will decide a matter which is before you, not in the area of any situation which is a chimera, which has no relevance to reality, and you just conjure up something. I mean, legislatures, if you say the governor acts on the presumption that he is the highest executive authority and therefore acts with responsibility, the same assumption must be made in the case of the legislature, that they are acting with responsibility. Then, Mullahs, in conclusion, para 29, in conclusion, an interpretation that gives the governor the executive power to withhold assent upends the entire constitutional scheme. The union's argument of separating the substantive part of 200 from the proviso allows the governor to avoid communication, bypassing reasoning, and ignore the primacy of the legislature, all while acting on his own and being immune from judicial review. This creates a one-time, first-instance veto, which is free from any kind of accountability. Such an interpretation builds a super-constitutional office wholly incompatible with constitutionalism, responsible government, and democracy. Then, Mullahs, comes the timeline issue now. So, no more than 6 months, within 3 months, forthwith. Now it's the architecture that you create, which will be the law. And according to me, the following. All this confabulation must happen before the bill is proposed. Any problem that he has, and I'm giving a solution, any problem that he has must be communicated before. And once the bill is sent to him, he must assent. Right. There may be an extraordinary situation that may happen. I'll accept that there may be some situation where he still feels that he refers it to the president. Fine. But as soon as possible, forthwith must apply to the governor, must also apply to the president, because the president acts on the aid and advice of the Council of Ministers. So it's the government of India. It's not the president. So the same, what should I say, necessity of incorporating the concept of immediacy must be engrafted in the action of the president once the bill is sent to him, for he has to send it back. And if it's passed again, he can't say no. That's how the Constitution will work. Otherwise, it won't work.
There is a qualitative difference in Article 201 later part.
I know.
As against the earlier article.
Correct.
It shall be presented to the president.
For consideration. But it doesn't matter. Let's compare the government of India.
No, I'm saying that he must grant assent is what you're saying.
No, true, but I'm saying that. Supposing your lordships were to say he need not grant assent, you create the problem. Well, ultimately, you will have to decide how it works. Let's assume your lordship is your lordship's thinking, let's take it forward. That he keeps it with himself. It doesn't respond at all. So the will of the sovereign legislature.
Founding. They are talking about a solution. Are we saying that the Constitution compels that a bill need to be assented?
Yes. Yes, absolutely.
It's like that.
Yes. No, I agree. That's my constitutional premise.
Doesn't contemplate a situation.
Yes.
Where a legislature passes a bill.
Yes.
And it is not assented to.
By the executive.
President.
The president is the executive with us. Because he acts on the aid and advice of council.
Analysis from the legislature, it goes to the governor.
Yes.
It could go back to the legislature.
Yes.
Then it comes back to the governor. Then first hurdle is that after that he can't refer it to the president. That's what. After he can't refer to the president, that also we need to find the textual requirement for that. And if it is permissible for him to send it, or even in the first instance, then the president considers, that's it. Constitutional text doesn't say that after his consideration.
Correct.
Why is it that specifically it is chosen? So therefore, as a court, we need to supply those words.
Yes.
Saying that the president has no option but to assent.
Correct.
You want us to supply this?
Yes, absolutely. Because that's the entire Constitution.
In the context of the larger principle of parliamentary democracy, federalism and separation.
Absolutely. But the consequences would be disastrous. If you allow the governor the personal power to take a decision, neither the government of India nor the government of the state is involved. How will 361 apply when it's the decision of the governor that I will not give you assent, or that I'm keeping the bill pending? Government of India can't defend him. Government of a state is at odds with him. So how will a writ petition lie? So you can't interpret 361 in this fashion. If you give that power to the governor, my argument is that you should not do so. But if you do give that power, then he's answerable. Then 361 will not stand in the way. You can't have it both ways. You take recourse to 361 saying he's not answerable, and you give him the power under 200, and you say governor will not file an affidavit, and court can't issue a process. Then you're making the Constitution unworkable. Because that's the only act in which he is not accountable. There is no act in the Constitution which makes the executive not accountable to the court. But this is a provision where you will give that. You can't have an absence of accountability as a constitutional provision.